that the name that was submitted to Parliament is not capable of replacing, in the event this court dismisses our petition and upholds the impeachment, the Deputy President of the Republic of Kenya. The court further said,
welcome, ladies and gentlemen. Thank you so much for your great support always. I'm so grateful for your continued support to this channel. Thank you so much, ladies and gentlemen. Now, Kenyans, regarding GACHAGUA's victory, is going to be sealed in these four areas. Number one, conservatory orders. Number two, the appointment of Kindiki is going to be illegal, as we had no IEBC to verify his appointment. Number two, public participation. The records that the National Assembly presented before the Speaker of the National Assembly, Moses Masika Wetangula. Number three, Kindiki's appointment, yet he was holding a public office. Those four areas. I want us to start with number one. As per the argument of regarding GACHAGUA's lawyer, he is coming out to argue saying that the conservatory order in a keep regarding GACHAGUA to be the deputy president still. In other words, regarding GACHAGUA should be in his office. Regarding GACHAGUA deserves to have security. Regarding GACHAGUA deserves to have government vehicles. Mshahara yake bado haijakatwa. Sawa sawa. About the conservatory orders. I want you to listen to Paul Mwite today. But before we do that, ladies and gentlemen, as we always do, just ensure you like the video. When you like the video, you automatically support the work that I'm doing in this channel. Because sometimes you watch the video and you forget liking the video. So this is just a reminder. As you watch, ensure you like the video. Let us listen to Paul Mwite.
My Lord, Your Ladyship, the sole purpose of conservatory orders under Article 23 of the Constitution, which gives this court power to issue conservatory orders, is to preserve the substratum, the subject matter of the petition. Here, what is being preserved is the right, constitutional rights of the Deputy President, who has challenged the impeachment for violating his rights, seeks to have that impeachment vacated and quashed. That is what needs to be preserved, and that is the purpose for which 3 judges issued conservatory orders, or 2 judges issued conservatory orders. But my lords, your ladyship, those 3 judges sitting separately, each one of them made a finding that there were serious, weighty constitutional issues raised that needed to be fully canvassed during the hearing of the petition, for the court to have the opportunity to give a considered decision on those issues, and therefore gave conservatory orders to preserve the subject matter so that the deputy president remains in office. There is no vacuum, there is no insecurity. My Lord, the best guarantor for security is observance of the rule of law, constitutionalism, and the Constitution. And this is the court that has that weighted duty of ensuring that that happens. My Lords, the weighty issues identified by the three judges are: one, the issue of public participation. The petitioner here says the public participation was a sham. We will be going into that through my colleagues. I'm just saying the weighty issues here. The second issue was the constitutional validity of Standing Order 68, giving a period of only 12 days to finish the whole purpose of the impeachment. And I would like to mention this issue of public participation, and indeed the time of 12 days, assumes added importance when we remember the wording of Article 1. The wording of Article 1 is that sovereignty remains in the people of Kenya. They have donated that power, that sovereignty, to your lordships, to your leadership, to the judiciary. They have donated their power to Parliament, the National Assembly, and the Senate, and they have donated that power to the executive. But the people of Kenya remain sovereign. That is why there must be adequate public participation in terms of the decision in the British tobacco case. The third issue was proof, the threshold, serious violations of the Constitution, which the Deputy President says do not exist.
Number two, we are having public participation. As I was just listening to the argument of GACHAGUA's lawyer, Ndengwa Njiru, about public participation. Remember, we are 50 million Kenyans. Sawa sawa. Number two, we are over 17 million registered voters. According to the public participation records that was submitted before the National Assembly, was all 225,000 Kenyans. Out of 50 million Kenyans, or if they don't want to use 50 million Kenyans, out of 17 million registered voters. So they were just able to have public participation, and the record shows the number of Kenyans that participated, they are 225,000. Can you see something there, Kenyans, if I'm not wrong? Listen to Ndengwa Njiru.
45 of the said Hansons. And most importantly, is the submissions that were made by Honorable Millie Odhiambo, the Member of Parliament of Suba North. At page 48, she makes observation that public participation had only two...
Do you have the Hansard as part of the affidavit?
Yeah, they have been filed.
They have been filed?
Yes, yes, my lady.
Where do we find them?
Is it part of the application?
It's part of the petition, my lords. That is 522, the Hansons.
Part of the application or part of the petition?
Petition.
Yes, then that's that. I mean, that is something different. You are dealing with the application.
But most importantly, my ladies, my lords, it went on Hansons that only 200,000 people purportedly participated in that process. That is to mean, my ladies, my lords, for Honorable Mutuse to have the guts and the audacity to move the motion, he had the backing of 200,000 people as against a population of 50 million Kenyans, or as against the population of over 14 million registered voters. What begs question for determination, was that a qualitative and a quantitative public participation? Was it meritocracy? Does it deserve the or could it convince that public participation that was adequate was conducted before the motion was moved? My ladies, my lords, to afford us an opportunity to bring this case out, we beseech you, my ladies, my lords.
Then it is a confirmation that Kindiki Kithure is likely not to take over. I might be wrong or right, but in my perspective way, I don't see any motive and defense from the Senate Assembly and the National Assembly is going to win this case. And I told you, if the court is not going to be biased, they are going to follow the Constitution. Remember, when the National Assembly and Senate Assembly were handling this issue, this was political process. But now, as we speak, it is a constitutional process. The parliament, they were to use political process plus constitutional process. But they negated and they decided to put aside the Constitution, which for me, according to the political process, they were right. In fact, wako right in the political process. But walifuata sheria. Hiyo ndio swali tunauliza. Wachana maneno watu wanatujaza na political process. I know. It is a political process. But the question is, did they follow the rule of law? Kwa sababu hata hao wenye wanatimuliwa kwa ofisi kama kina Rigathi Gachagua, Constitution protects them. And that is why the 2010 Constitution is so strong defending the deputy president. Not as it was, where a vice president alikuwa anaamka asubuhi na anang'atuliwa kwa mamlakani. That what I think part of Mwai Kibaki presidency and Moi, you saw it. So during the regime of Uhuru Kenyatta, the deputy president ameprotectiwa sana. Sasa hakuwa anaitwa vice president, ni deputy president. So Rigathi Gachagua's victory is likely to be sealed. Na munaweza shangaa Rigathi Gachagua kuwa deputy president till 2027. Till 2027. But if any case Rigathi Gachagua will not be satisfied, after the court has quashed the impeachment trial resolutions that came from the Senate, then Rigathi Gachagua will be reinstated after the court quashed the impeachment trial process resolution. Then Rigathi Gachagua is going to be reinstated as the deputy president fully. Then if they are not satisfied, they will start another impeachment motion. But in that process, Rigathi Gachagua will realize that no, these people bado wanarudi na ile tabia na nisumie sana, let me resign. But there are two scenarios that might come. If Rigathi Gachagua, this case is going to be quashed, then he's going to be reinstated, then he will have two decisions. Either to be down, yani arudi chini kabisa na kuwe loyal to president, na aombe msamaha completely na waendelee mpaka 2027. Ama hao watu wakikataa waendelee tena kumimpeach, ataresign. Ladies and gentlemen, as simple as that. I don't want to add anything. Jijazie ni nini inaweza endelea? That is just my opinion. Drop your opinion. You have a right to give your opinion at the comment section below. I will appreciate you so much. Thank you so much for watching this video. Ensure you like the video, you comment and share. Subscribe. Bye bye till you meet in another video.